courtroom earthquake. Picture this: California, the most restrictive gun law state in America. For decades, politicians piled rule upon rule. One gun a month, sweeping bans, endless waiting periods. And behind it all stood the Ninth Circuit Court of Appeals, rubber stamping nearly every restriction that crossed its bench. Cases like Peruta versus San Diego, 2016, which challenged California's good cause requirement for carry permits, were crushed. Rupp versus Bonta, a lawsuit targeting the state's assault weapon ban, met the same fate. Gun owners nicknamed the Ninth Circuit the graveyard of the Second Amendment. And yet, in August 2025, the unthinkable happened. The same Ninth Circuit issued its first ever Second Amendment mandate. Not a temporary panel ruling, not a decision awaiting en-banc review, but a final binding order that struck down California's one-gun-a-month law. For the first time in 134 years, the Ninth Circuit wasn't the graveyard. It was the battlefield of a massive victory, and that was only one piece of the story. On the same timeline, Minnesota's under 21 carry ban fell apart. Washington, D.C. prosecutors began quietly backing away from outdated carry charges. And in Tennessee, courts dismantled the state's sensitive places ban on parks. 3 different fights, 3 different states, but one clear message: the age of carry bans is collapsing. Chapter 1. Tennessee cracks the sensitive places wall. The first domino fell in Tennessee, and it went straight to the heart of a favorite tactic used by anti-gun lawmakers, labeling almost every public space a sensitive place. For years, the list grew longer. Schools and government buildings were the starting point. Then came public transit and libraries. Eventually, entire categories like parks were declared off-limits. By 2023, the map looked absurd. Critics argued you could cross a city and never pass through an area where carry was legal. The exception had swallowed the rule. Enter the Bruen decision, 2022. The Supreme Court said states can't just declare somewhere sensitive by preference. They must show that restrictions have clear historical roots, consistent with 18th or 19th century laws. And when Tennessee tried to justify its park ban, history wasn't on its side. Public carry in open spaces was expected, not forbidden. The breakthrough ruling, 2025. A federal appeals court struck down Tennessee's ban. The opinion made clear: vague, sensitive place arguments are not enough. If a state cannot tie its restriction directly to America's history and tradition, the law fails. Why it matters nationwide. This isn't just about Tennessee's parks. The precedent now threatens similar restrictions in New York, Illinois, and Hawaii, where lawmakers tried to stretch sensitive places into near-total bans. For gun owners, this ruling is more than one victory, and one it's a framework. The first crack in the wall of arbitrary carry restrictions. Tennessee proved the point. Once courts enforce history and tradition, the endless list of sensitive places starts to crumble. Chapter 2. Minnesota's young adults get their rights back. The next turning point came from Minnesota, and it spoke directly to a generation that had been excluded from their own constitutional rights. For decades, Minnesota law flatly denied carry permits to anyone under the age of 21. That meant 18, 19, and 20-year-olds, adults who could vote, sign contracts, serve on juries, and even fight and die for their country, were told they couldn't carry a handgun for personal defense. But history told a very different story. When the Militia Act of 1792 was passed by Congress, it didn't set the cutoff at 21. It required all able-bodied men aged 18 to 45 to equip themselves with a musket and ammunition. That wasn't optional. It was the law. The founders didn't see 18-year-olds as children. They saw them as citizens with responsibilities. Using that history, a legal challenge rose against Minnesota's age restriction, and in early 2025, the courts struck it down. The decision was clear. If young adults were expected to defend the nation at 18, they certainly cannot be barred from defending themselves. In April 2025, the Supreme Court declined to reverse the ruling, effectively cementing it as law of the land. Overnight, Minnesota's under 21 ban collapsed, and so did similar laws in other states. This wasn't just a courtroom win. It was a restoration of rights for millions of young Americans. For the first time in decades, 18 to 20-year-olds could fully exercise Second Amendment rights the founders always intended for them to have. Chapter 3: Washington, D.C. retreats. Then came the quiet shift in Washington, D.C. For years, the nation's capital was infamous for its strict enforcement. Residents were criminally charged for small, technical mistakes. A holster that didn't meet the district's requirements, a firearm transported across a city line with paperwork slightly out of order, or a visitor whose out-of-state permit was worthless the second they crossed into D.C. These weren't violent criminals. Many were ordinary, law-abiding people who got tangled in red tape. Yet the penalties were serious. Heavy fines, confiscations, even jail time. But after Bruen, the cracks began showing. Judges started siding with defendants. Appeals courts overturned convictions. And by mid-2025, even the D.C. Attorney General's office had to face reality. Continuing to prosecute carry cases under outdated laws was a losing battle. So they stopped. Quietly, prosecutors began dismissing carry-related charges. No major press release, no public acknowledgement, just case after case dropped. That retreat said more than any official statement could. Even in one of the strictest jurisdictions in America, the government recognized that the legal ground had shifted under their feet. What once seemed like an untouchable stronghold of gun control was now too fragile to defend. Chapter 4: Bruen's shadow grows longer. If Tennessee lit the spark and Minnesota fanned the flame, then the Bruen decision of 2022 is the fire that keeps burning in every courtroom today. Before Bruen, courts often used something called interest balancing. Judges would weigh the government's claimed interest in safety against your constitutional rights. Time after time, safety was declared more important, and the Second Amendment lost. But Bruen tore that playbook apart. The court ruled that modern gun laws must align with America's text, history, and tradition. No more balancing tests. No more public safety excuses unsupported by history. That standard has reshaped everything. Think about it. Magazine capacity limits in California, assault weapons bans in Illinois, carry restrictions in New Jersey. They all now live or die based on whether they resemble laws from the founding era. If history doesn't support the restriction, the law collapses. And that's exactly what's happening. Tennessee couldn't show historical bans on carrying in parks. Minnesota couldn't point to any tradition of excluding 18 to 20-year-olds from the right to bear arms. Even D.C. prosecutors couldn't find history to justify treating paperwork errors as crimes. Bruen turned the Second Amendment from a paper promise into a practical shield, and now every ruling, every mandate carries that same shadow, forcing courts to answer one question. Is this restriction rooted in the nation's history, or is it just political preference? Chapter 5: The Unprecedented Moment. All of this set the stage for something that had never happened before. For 134 years, the Ninth Circuit Court of Appeals was the graveyard of Second Amendment claims. Gun owners knew what to expect when they walked in: delay, denial, and disappointment. Case after case, from Peruta versus San Diego, where the court upheld restrictive concealed carry laws, to Rupp versus Bonta, where challenges that California's assault weapon ban stalled, ended the same way. Rights pushed aside. But August 14, 2025 broke that cycle. In One versus Bonta, the Ninth Circuit didn't just issue a favorable panel ruling, it went further. It issued a final mandate striking down California's 1 in 30 law. That meant no rehearing en banc, no endless limbo, no second chance for the state to drag the case out. The ruling was final, binding, historic. For the first time since its founding in 1891, the Ninth Circuit Court of Appeals struck down a gun control law on Second Amendment grounds and let the mandate stand. Think about the significance. The very court known as the harshest toward gun rights became the court that delivered one of the most important victories in history. Legal scholars call this a constitutional inflection point, the moment when a long-standing judicial trend finally turns in the opposite direction. And for gun owners, it's more than symbolism. It's proof that the tide has shifted. The wall of resistance is breaking, and the cracks are visible for the whole country to see. Chapter 6: California's fortress finally breaches. For decades, California was the fortress of gun control. Its one gun a month law was designed not just to regulate purchases, but to send a message. Rights can be rationed. Buy one pistol in January? Don't even think about buying another until February. But after years of litigation, Duncan versus Bonta reached a historic conclusion. On August 14, 2025, the Ninth Circuit did the unthinkable. It issued a formal mandate striking the law down. That's not a temporary panel win. That's a final order. No en banc review. No Supreme Court remand. Done. Judge Roger Benitez, who earlier dismantled California's magazine ban, had warned years ago that rationing rights is no different than rationing free speech. The Ninth Circuit now agreed. For the first time, the state's fortress cracked, and the breach wasn't symbolic, it was binding. Chapter 7. The Dominoes in Motion. History shows us that once a legal precedent shifts, momentum builds, and right now, the dominoes are falling one by one. Key examples of this momentum: Illinois, facing a sweeping assault weapons ban, passed in 2023. Lawyers are citing the Ninth Circuit's mandate and Tennessee's ruling to argue that you can't ration or strip rights without history to back it up. New Jersey, its so-called carry killer bill, stuffed dozens of new sensitive places into law. But courts are now demanding proof that these bans match historical traditions. And the state can't find it. Hawaii judges are questioning whether its strict carry restrictions can survive after Tennessee made clear you can't just declare every open space off limits. Why it matters. These aren't isolated battles. They are sequential dominoes. Each victory gives attorneys a stronger precedent for the next case. When enough dominoes fall, the wall of restrictions collapses nationwide. This is how change spreads. A single mandate in California combined with rulings in Tennessee and Minnesota now fuels challenges across the country. Chapter 8. The Counterattack from Politicians. But victories don't mean the fight is over. They shift the battlefield. And state politicians are already launching a counterattack. California's move. Immediately after the Duncan mandate, lawmakers pushed AB 1078, limiting purchases to 3 guns per month. It looks like a loosening compared to the old 1 gun a month law, but in reality, it's the same playbook. Ration rights, repackage restrictions, and drag it out in court. New York's strategy. After Bruen gutted its carry law, legislators scrambled to rewrite it. They added entire city blocks, subways, churches, and public parks to the sensitive places list. The result? Nearly the entire state turned into a carry-free zone. Why this may backfire? Courts are tired of legislative games. Bruen doesn't allow endless reshuffling. Either a law is rooted in text, history, and tradition, or it fails. By repeatedly pushing weak restrictions, states risk losing credibility in the courts. In other words, every counterattack that collapses only strengthens the overall precedent for gun rights. The more they push, the more they lose ground. Chapter 9. What it means for you. It's one thing to talk about precedent, it's another to see how it touches everyday lives. Picture a single mom in California who, after surviving a break-in, wants to buy a second firearm for home defense. Under the old 1 gun a month law, she'd be told to wait 30 days. As if threats follow a government calendar. Today, that roadblock is gone. Imagine an 18-year-old student in Minnesota walking home late from campus. Before, he had no legal way to carry for protection. After the court's ruling, his rights are restored, aligning with the very militia responsibilities that young adults carried at the nation's founding. Or consider a shop owner in Washington, D.C. For years, he risked prison over a misplaced form. Now, prosecutors are dropping those technical cases because they know the Constitution no longer allows them to treat paperwork errors as crimes. These are not abstract rulings. They're changes that protect real people in real situations every single day. Chapter 10. The Dawn of a New Era. For more than a century, the Ninth Circuit was known as the graveyard of the Second Amendment. If you brought a gun rights challenge there, odds were simple. You'd lose. Every time. For 134 years, that was the reputation. But now, history has flipped. The same court that once buried gun rights has become the place where they're being reborn. Why this moment is different? Courts are no longer satisfied with political arguments. They demand history, tradition, and text. The standards laid down in Bruen. Legislatures can't ration rights like coupons anymore. One gun a month or endless sensitive place bans fail when stacked against the Constitution. Once courts consistently enforce rights, freedom grows faster than anyone expects, because each ruling builds momentum for the next. Key fronts that prove the shift: Tennessee knocked down the sensitive places wall by restoring carry rights in parks. Minnesota restored full rights to 18 to 20-year-olds, grounding it in militia history. Washington, D.C. backed away quietly, dropping cases it knew would collapse in court. California, forced by a mandate to end its one-gun-a-month rationing scheme. What it all means: these aren't isolated victories, they're building blocks. Together they mark the beginning of the end for carry bans, rationed rights, and patchwork restrictions nationwide. The Ninth Circuit's transformation signals something larger, a new era where courts protect rights, not bury them. And if history tells us anything, it's this: once the courts start enforcing rights consistently, freedom doesn't just return, it accelerates. Your role in this fight. This is a historic moment, but victories don't defend themselves. States will keep testing the limits, new bills will keep coming, and the fight will continue. So here's what I want you to do. Share this video with your community. People need to know these rulings are real, not rumors. Drop a comment below. Does this ruling make you feel more secure, or do you think states will push back harder than ever? And most importantly, subscribe to Survival Firearms. This is where you'll get clear, accurate updates on the battles that actually shape your rights. Stay sharp, stay prepared, and stay free. We'll see you in the next one.